Good afternoon. My name is Todd Stevens. I'm the chair of the Pennsylvania Commission on Sentencing. We are here for the March 9th public hearing on the working draft of the sentencing guidelines revisions. I'd like to start by just having the other members of the commission introduce themselves.
Hi, hello. I'm Judge Tamara Bernstein, or Tammy Bernstein, out of Cambria County. I'm a Court of Common Pleas judge.
Ed Marsico, judge here in Belford County.
Good afternoon, State Representative Rick Krajewski, 188th District.
Good afternoon, George Little, Acting Secretary, Department of Correction.
Good afternoon, Judge Leon Tucker, Philadelphia County.
Good afternoon, John Rago, Duquesne University School of Law.
Good afternoon, Doug Marsico. I'm an attorney in Harrisburg, Pennsylvania, representing criminal defense bar.
Senator Street, I think I see you on there.
Yep. Good afternoon, Senator Sharif Street, representing the Senate Democrats.
Judge Craig Daly, Northampton County Court of Common Pleas.
All right. We have a good problem today. We've had a tremendous response and interest in testifying before the commission. So we have, we're going to begin with a former member and chair of the commission and someone with whom the commission works pretty regularly in his role as a professor of law at Villanova University. Professor Steve Chanenson will kick things off, and then we're going to move to the in-person testifiers and work through this list going forward here. So if we could get Professor Chanenson up on the screen for us.
All right. Good morning or afternoon, pardon me.
Good afternoon. It's good to see you again.
It's good to see you. Well, Chair Stevens, Vice Chair Bernstein, members and staff of the commission, good afternoon. As Chair Stevens said, my name is Steve Chanenson. I want to thank you for the opportunity to address the commission on this vital topic. In my comments, I hope to convince you that you are on a solid and productive trajectory that will continue to improve the state of criminal justice in the Commonwealth. I speak here today solely as a private individual, but I bring the perspective of someone who has seen and worked both the state and federal criminal justice systems for decades. By way of background, I'm a professor of law at Villanova University Charles Widger School of Law, where I teach and write about criminal sentencing. I'm the managing editor and frequent contributor to the Federal Sentencing Reporter. And I was, as Chair Stevens said, privileged to hold what is best viewed as the Al Bloomstein seat on the commission, more recently the John Rago seat. I do see a Pittsburgh theme here. I was a member of the commission from 2002 to 2015, having been appointed by 3 successive governors of the Commonwealth of both major parties. And for my last few years, I served as the vice chair and then the chair of the commission. As chair, working with the executive director, Mark Bergstrom, Pennsylvania's Iron Man of sentencing, I led the commission's strategic planning work group. More recently, I was honored to participate in the commission's academic review panel led by Judge Tucker. So I come to this with a bit of historical perspective, even though I'm no longer enmeshed in the day-to-day details of Pennsylvania sentencing. When we first started the strategic planning work group, a key goal was to take control of the commission's destiny. There was a concern that the commission had become too reactive. It was responding, as it should and must, to legislative directions. Yet I feared that the commission was being reactive to the exclusion of exercising its proactive judgment and authority to craft, as its enabling legislation provides, recommendations, quote, the commission finds to be necessary and advisable to carry out an effective, humane, and rational sentencing, resentencing, and parole policy. So I want to congratulate the commission for promulgating its working draft of sentencing guideline proposals. Re-examining current practices and turning ideas for improvement into concrete proposals is a Herculean task, and one that can often feel Sisyphean, but it's worth the effort. Your work here is consistent with the spirit, if not quite the letter, of the recently completed American Law Institute's Model Penal Code sentencing, which calls for a regular omnibus self-assessment of sentencing. In other words, blithely saying that we have always done it this way is never a sufficient explanation. Stakeholders in the criminal justice system, and we are all part of that group, must constantly be questioning, learning, and improving. And you are. The Pennsylvania Commission on Sentencing has long been a national leader in this field. The commission has promoted groundbreaking and often praised and copied policies and practices on a range of topics, including the treatment of intermediate sanctions, fines, data collection, research, transparency, and misdemeanors. Although perhaps the fact that our M1s and M2s are often felonies elsewhere makes that a little easier. Yet there are also areas where the commission's approaches have been questioned within the Commonwealth, as well as seen as outliers elsewhere. You have quite properly addressed some of those topics in your current draft and sought feedback. Your proposals are bold without being radical. They are innovative while respecting Pennsylvania's distinctive historical experiences. I want to highlight two specific topics. While they will likely be refined further, I think the commission is headed in the right direction. The first should fall under the category of the past is a foreign country. Criminal history is an especially complicated aspect of sentencing. We're all familiar with the old saying that what is past is prologue, but we also know that there are limits to that aphorism. The commission properly recognizes that the current system puts too much weight on past offenses and fails to account for stale convictions. This is one of those areas where Pennsylvania is out of step with many other jurisdictions, as well as an emerging academic consensus. The proposal moving from 8 to 4 PRS categories is a big improvement. It isolates the real first offenders, what some judges now call true zeros, and identifies those with multiple serious offenses. I also encourage the commission to push forward with lapsing provisions. Reasonable minds can differ about the details of handling certain long ago convictions, but making a change here is vital. Whatever predictive power these old convictions have does wane, and the proposed system remains well equipped to deal with individuals before the court for a new sentencing, even if their previous convictions lapse for PRS purposes. My other topic probably falls under the title of True Grid. The ideal size and number of sentencing matrices, maybe you want to call it a sentencing table or a grid, can be not just a matter of debate, but almost one of taste. What feels right? What makes us comfortable? Make it too small and there isn't enough guidance. Make it too big and it becomes unwieldy and almost algebraic. In the basic matrix, Pennsylvania currently has 112 standard range boxes or cells, excluding murder 1 and 2. Of course, that triples if one includes mitigated and aggravated ranges. Moving to 144 standard range boxes, again, excluding murder 1 and murder 2, will require an adjustment period, and for me as much as for anyone else. But remember that this is not being done in a vacuum. The original idea flowed in part from a concern about the need to, and I'm quoting from the Strategic Planning Work Group report now, incorporate and better manage the numerous enhancements and to promote greater certainty and more efficient use of correctional resources. In other words, we have an admittedly familiar, but far more convoluted system now. I urge you to step outside of your experience and try to explain the current Byzantine process to an educated layperson before deciding whether the current approach, which includes 7 matrices, or the proposed tact with just 1 matrix, is more complicated. Also, remember the need, founded in basic fairness, for roughly similar defendants convicted of roughly similar offenses to be treated in a roughly similar fashion. There are recurring situations, such as guilty pleas, course of conduct, role in the offense, that for no defensible reason are treated differently from county to county and courtroom to courtroom, without much in the way of coordinated recommendations. The new matrix is designed to keep general severity amounts constant while accounting for common sentencing factors. Of course, there are going to be definitional challenges, but that is part of any legal drafting process. To shrink from this task would be to surrender to the idea, false in my view, that there are no recurring factual situations that merit a consistent set of guideline recommendations for the judge's consideration. I'm also thrilled to see a commitment to addressing multiple sentences. Frankly, it's long past time for the commission to say something about concurrent and consecutive sentences. I recommend following the Model Penal Code sentencing approach and establishing a general recommendation in favor of concurrent sentences with exceptions for certain categories of cases, perhaps crimes against the person, where the recommendation would be for consecutive sentences up to some limit. Although our use of discretionary parole release should make this process easier, it will be a tough needle to thread. Nevertheless, remaining silent is an abdication of responsibility and undermines the entire guideline project. The sharpened and clarified approach to levels is a logical tactic. The proposed additions of a new level of non-probation restorative sanctions and a new level with probation duration recommendations of increased specificity are particularly welcome and natural steps towards more helpful guidance for Pennsylvania judges. The Pennsylvania guidelines will and should continue to be advisory, but your new proposals will make that guidance more useful. As Professor Michael Tonry, one of the leading sentencing scholars in the world, wrote more than a quarter century ago, like all calls for just the right amount of anything, not too much and not too little, a proposal for sentencing standards that are constraining enough to assure that like cases are treated alike and flexible enough to assure that different cases are treated differently is a counsel of unattainable perfection. Nevertheless, that is probably what most people would want to see in a just system of sentencing. Your proposals allow for a more meaningful pursuit of that unattainable perfection. Sentencing is hard. Indeed, the late Judge Irving Kaufman of the Second Circuit Court of Appeals once described sentencing as the most trying facet of the judicial vocation, and the one where the judge feels the most alone, in part because no other task carries greater potentialities for good or evil than the determination of how society will treat its transgressors. Yet, thanks to the Pennsylvania Commission on Sentencing, judges in the Commonwealth have company. While they usually must make the difficult final decision about the nature and duration of punishment by themselves, they do so with the benefit of considerable guidance. Your proposals will continue to make that job easier. Thank you for your time.
All right. Thank you, Professor Chenenson. I appreciate the thoughtful commentary. Any comments or questions from any members of the commission? No, there's none in person. Do any of the online members of the commission have, or virtual members of the commission? I guess they're not virtual members, they're real members, but they're virtually joining us. Members of the commission.
The jury is still out on Rago.
All right. I don't see anybody indicating they have any questions. Again, thank you very much for your interest here. And I know that you were so involved with the strategic planning work group, and this is an extension of that work. So certainly appreciate your insights there. Thank you very much for joining us.
Well, thank you for having me. Take care.
So long. All right. We will now turn to the folks who are registered to testify in person, and we will start with Mary Ann Stein from the ACLU. One of the things, if we could, we do have, I think we have over 30 people to testify. So for everyone testifying, if you could do your best to try to constrain your testimony. I know many individuals, if not most, have submitted online testimony, and we will still receive online submissions. So if folks want to email written testimony, I'll provide that email address here shortly. We will receive that and certainly consider that and make that a part of the record. But I just wanted to ask if folks could help us by trying to hit the major points of their testimony and highlight it for us. That would be very helpful and appreciated. Thank you.
Can you all hear me okay? Okay. Thank you, everybody, for having me today. Well, thank you so much, commission members and staff, for holding all these public hearings. I know that this is the 6th one, so I'm sure you're all very exhausted. My name is Mary Ann Stein. I am representing the ACLU of Pennsylvania this afternoon. I want to give a little bit of background, just so you know some of my experience. Prior to working with the ACLU, I worked for the Sentencing Commission for a short time. Prior to that, I worked in adult probation in Lancaster County. And prior to that, the majority of my career was spent working in drug and alcohol counseling and prevention. So a lot of this work intersects with my experience. Again, we really appreciate you taking the time to listen to all of us and give our feedback on these guidelines. The working draft of the proposal states that the rebuilding of the guidelines serves as a vehicle to reform and improve Pennsylvania's criminal justice system, while giving renewed focus to concerns about racial justice and the over-reliance on incarceration and long periods of community supervision. We urge the Commission to use this important opportunity to meaningfully address Pennsylvania's mass incarceration crisis, and you have taken some steps to do so. We recognize many of the positive changes, including the recalculation to prior record score and including adult convictions for lapsing provisions, mitigating sentence factor adjustments, and the 1-point reduction in offense gravity scores for all inchoate offenses. We support the use of mitigating sentencing factor adjustments. However, the list of mitigating factors should be vastly expanded and broadened. I know that the Defender Association of Philadelphia gave some proposals for mitigating factors, so we would defer to those. Additionally, the aggravating sentencing factor enhancement should be eliminated from the working draft proposal. There are plenty of opportunities for prosecutors to increase sentences as it is. The Commission's primary responsibility is to ensure fair and uniform sentencing across the Commonwealth, not find new ways to incarcerate people. The recalculation of prior record score is an improvement. The recalculation will decrease the impact of a person's prior record for individuals with lengthy and more serious prior records. But because of this calculation, as you've heard before from many others that testified before me, it is likely that harsher penalties will be applied for people with less serious but more frequent contact with the criminal legal system. And this particularly affects our people with mental health issues and drug and alcohol issues. We also recommend that the Commission use the recommendations from Professor Lopez's work with her students in 2019 and use the decay form of lapsing rather than gap for less serious crimes of felony 3 or less. We also encourage the Commission to define crime-free as including time spent in detention, incarceration, or juvenile placement. The proposed sentencing matrix includes narrower ranges and expansion of the offense gravity score. We are concerned this can limit opportunity for mitigated sentences, and it might limit opportunities for judges to give lesser sentences or to give non-carceral sentences. Also, the Commission increased the lower end of the sentencing range for many sentence recommendations, particularly for possession with intent to deliver and second and subsequent offenses. The ACLU PA urges the Commission to prioritize decarceration, and we have several recommendations to further this goal. We recommend the Commission incorporate recommendations from their recently published report, The Role of Substance Use in Probation Outcomes. Some of the recommendations include evaluating people for substance use and mental health issues prior to sentencing, and then crafting an appropriate sentence to meet the rehabilitative needs of the person. Also improving access to evidence-based treatment at time of sentencing, and considering expanding the sentencing levels of offenses for which alternatives to incarceration are available. We also urge the commission to remove the school zone enhancement. I don't need to tell all of you this. You know that those mandatories were found unconstitutional. So we are wondering why that's still in the guidelines. The proposed guidelines should also include a notation for all enhancements and adjustments, not just trafficking, arson, and sexual abuse of children, that the OGS enhancement does not apply if the OGS offense listing assignment is already included in that enhancement factor. The commission has added restorative sanctions to the sentencing matrix, which is great, that don't include probation. However, there are very few assigned a low offense gravity score. And again, you've heard this before, tampering with kosher food and burning a flag are not the typical offenses we see coming through the criminal legal system. So we are urging the commission to expand the non-confinement sentence recommendations and also apply lower offense gravity scores to more offenses. Any reforms to the criminal legal system must take into account the racial impact of those changes. We're urging the commission take racial disparities seriously and conduct a racial impact statement before implementing any new changes to the sentencing guidelines. So again, we're asking the commission to prioritize decarceration first and foremost in the guidelines and focus on the rehabilitative needs of people in the criminal legal system. And I'm happy to answer any questions.
All right. Thank you very much. Appreciate your testimony. Any questions or comments from any members of the commission? Yes, go ahead, Representative Krajewski.
Thank you, Chair. And thank you, Marianne, for your testimony. I had a couple questions. One was you had referenced the recently published report that had several recommendations for the Sentencing Commission to consider. And I wanted to ask if you could just speak a little bit more about what those recommendations are. And from your personal experience, since you expressed that you have worked in drug and alcohol treatment, why you think that is both in the best interest of the individual and also the Commonwealth to adopt those recommendations.
Sure. So the first recommendation from that report says to evaluate people for substance use issues or mental health related issues prior to sentencing. The reason for this is to give an opportunity to inform judges from experts that work in this field to enable them to create a more individualized and appropriate sentence to meet the rehabilitative needs of folks that are coming through the criminal justice system. That can then reduce recidivism if they're having their needs met for mental health crises. Trauma is another thing we see with a lot of people in the criminal legal system, and drug and alcohol. So in my experience, jail was the last person for the place to be for a mental health crisis. We've all experienced some form of anxiety in our life. So being put in a cell is probably not going to help that. And also there is very, very limited treatment options and resources in the county prisons for people that are struggling with drug and alcohol issues.
Thank you for that. It definitely seems like it would be in the interest of both the system itself and also the individual to try to think about some alternative sentencing for those folks. And then my second question was, in your testimony, you also spoke about advocating for time incarcerated to count towards the crime-free time for lapsing of previous sentences. And this is something I also tried to advocate for during some previous meetings. And I wanted to ask if you could just speak a bit more about the reasoning for incorporating that.
Sure. From a logistical standpoint, I don't know who's going to keep track of that. That seems like very, very difficult, considering that people get picked up on failure to pay child support. People go in for punitive sanctions if they're involved in a problem-solving court. Is that going to count? Probation violations. So there's a lot of other factors to consider when including crime-free, including for the definition for crime-free.
Okay, excellent. Thank you. Those are all my questions.
All right, thank you. Any other questions? Judge Marsico?
You said something about PWI and I lost you. What were you talking about with that?
So the second and subsequent, for possession with intent to deliver, those recommendations are very, very high. They're significantly higher than the current. And I do have some sample cases I can share with you.
Based on the drug or the weight?
It's just across the board. they are increased. And as you know, with the proposed recalculation of prior record score, that will already be taken into consideration for their prior record.
So would you have us have that part of the prior record score or part of the OGS?
Neither. Well, I mean, if you're going to count it in the prior record score, it absolutely should not be counted in second and subsequent provisions. It's double dipping.
But isn't that one area of the law where we see repeat offenders that are, there are serious problems that you've worked in drug and alcohol,
Mhm.
you know, that's who's purveying those individuals causing their addiction.
Sure. And I would also say that a lot of those individuals are probably suffering from a drug and alcohol issue themselves. And they should probably be in treatment or some form of that.
I gather that, but there's also some that are strictly business people.
And I think that judges have plenty of room to use to aggravate a sentence already.
With regard to the lapsing,
Mhm.
so if somebody served, let's say somebody served 10 years in SCI, gets out, you would, that whole 10 years, you would have us not consider, or consider, I guess.
That would
the
be,
lapsing provision.
yeah.
All
Mr.
right.
Chair, this is Judge Tucker. I'd just like to follow up on that. Marianne, thank you for your wonderful testimony, but if you could just explain a little bit more in detail about the last question. It's your thought that a person serving 10 years for that 10-year period should be considered crime-free?
Yes, I do think that. If a person commits another crime when they are released from jail, then they will be punished for that due to offense gravity scores representing the seriousness of that crime. So it's not like they wouldn't be punished. This is, that would be considered a stale prior record, something that happened 10 years ago.
Well, let's shorten the time. Let's say 3 years or 2 years.
I
I'm
would-
just
I
trying
would
to
s-
get, I'm just
Mhm.
trying to get to the foundation and the basis of,
Yeah.
of the foundation of what your thoughts are.
Yeah, Judge, I would say not only would it be difficult to keep track of that time, but again, the offense, if a person commits offense again, then there will be a sentence for that offense, obviously. So they will be sentenced on the offense they committed, not the offense they committed 10 years prior or 3 years prior.
Okay, thank you very much.
Mhm.
Appreciate your
I-
testimony.
I have a quick question as a follow-up because do you have any thoughts or suggestions for the individuals who are given the opportunity for treatment, or in some cases given opportunity after opportunity for treatment, in any type of resentencing guidelines for those individuals? I understand addiction, I think pretty well. I've been to a ton of trainings and we see it every day on the bench. And in theory, I think everybody would say, let's get treatment, let's get mental health. But in practical application, I can send somebody for behavioral health treatment if they can get in line and get the treatment, even if they are receiving it. I can't make them take the medication, which we see all the time. I can't make them maintain their treatment, which we see all the time. So I'm curious, at what point do we just, do we resentence, or what are your suggestions for those individuals?
So that is addressed in those recommendations in the report. One of them is to, as I mentioned prior, to expand assessments. So a person getting a PSI, that's administered by a probation officer. Same with a risk assessment. Those folks are not qualified to assess for mental health needs and trauma needs and drug and alcohol needs. So expanding assessments would then help get people the level of care that they need. And the level of care can range from attending support group meetings or complying with recommendations from your physician to inpatient treatment. There is no one size fits all approach for this space.
But for those people who've been evaluated,
Mhm.
have been given those opportunities and don't, you just said get compliance with their physicians. No one can make them comply. I'm just curious, at what point do you see there as something that's in a perfect world? I love it, but it's not all available. But even if we provide all of that, I have people coming in after 4 or 5 stints and continuing to commit crimes and committing to not taking care of their treatment. So on those, I'm just asking, is there a suggestion, or is that just something for us to contemplate?
I will say this, it takes people, I mean, anywhere from 2 to 16 attempts to achieve sobriety or recovery. So this is the world we're living in. And I would say we just have to work with people to try to meet them where they're at. I understand it's not an easy task, Judge.
Chair, can I just follow a quick comment on that?
Just wanted, Judge, are you finished your question? Okay, thanks. Go
Sorry
ahead.
about that. Thank you. Just to, I think, to add on to that as well. I think that oftentimes with a lot of people who are particularly struggling with drug or alcohol treatment, there are environmental issues that I think the courts are just unable to solve. You know, if someone is continuing to come in and out of the system because their record or their circumstances are preventing them from getting stable employment, or they're not able to access the mental health resources they need, or maybe they're not getting appropriate housing. These are kind of environmental issues that the courts or the purview of the sentencing system are just going to be unable to solve. And so I think part of Marianne's testimony is also kind of asking us to really think about that. At what point are there other recommendations or paths possible that don't just involve kind of having this person again and again and again going through something that's obviously not working.
All right. Any other questions for Ms. Stein? Thank you very much. We appreciate it. All right. Next up in person is Joseph Welsh from the Lehigh Valley Justice Institute. Mr. Welsh, thank you for joining us. Thank you. Hang on one second. There we go.
That helps.
Especially with the folks online, we need that microphone
Right.
on so they can hear. Thank you.
Good afternoon. I want to thank the members and staff of the Pennsylvania Commission on Sentencing for affording me the opportunity to present testimony on behalf of the Lehigh Valley Justice Institute. The Lehigh Valley Justice Institute, or LVJI for short, is an independent, nonpartisan research policy and advocacy organization working to develop and promote a reimagined criminal justice system that is equitable and fair for all communities. LVJI employs a data-driven approach focused on the criminal justice processes of the Lehigh Valley area of Pennsylvania, specifically the Lehigh and Northampton counties. We were formed in late 2020 and have begun our study of criminal justice with a staff including researchers, data scientists, and economists, and numerous volunteers from our board and the community. We hope to be a trusted community partner to both government agencies and community organizations. We have reviewed materials related to the working draft. We have also reviewed the analysis conducted by the American Civil Liberties Union of Pennsylvania. We are generally in agreement with the positions taken by ACLU, in particular, the overriding consideration that we must move in every responsible way to reduce the number of people incarcerated or subject to supervision through the systems of probation and parole. We should be taking advantage of every opportunity to reduce the footprint of mass incarceration upon our Commonwealth. But I would like to focus my remarks just on one aspect today, and that is racial disparities. We wholeheartedly endorse the concept of a racial impact study prior to implementing criminal justice reforms. During our work over the past year, we have seen racial disparities in various aspects of the justice system. We are at this moment finishing an analysis of 3 years worth of data related to bail decisions in Lehigh and Northampton counties. We have seen racial disparities in that data. We have also seen disparities in police interactions, and we are working with our local police departments to obtain and analyze relevant data. In the context of juvenile detention, working with our 2 counties, we have looked at programs to reduce the number of juveniles in detention. Unfortunately, most reform measures do not reduce the racial disparity in such detentions, and in some cases actually increase that disparity. And this is also a phenomenon which you've seen in the context of cash bail reform, where we can reduce the overall populations incarcerated pre-trial, but struggle to address the racial disparities. Nor is this an issue which we have found unique to the criminal justice system itself. This past week, LBJI released a study of the past 10 years of landlord-tenant cases in Lehigh County. This was completed to guide county officials interested in addressing the eviction crisis, and also because housing is a key to criminal justice reforms, such as pretrial release and reentry programs. Our analysis showed that the racial makeup of a magisterial district was more closely correlated to case outcomes than even per capita income of the district. Or to put that another way, if we statistically control for per capita income, there is still a statistically significant racial disparity in the outcomes of landlord-tenant cases. The ubiquitous nature of these racial disparities should really not come as a great surprise. Our society at large is still suffering many of the effects, the long-term effects, from a nation founded upon slavery. There is no reason to expect that our criminal justice system would be immune from these effects. And this is all the more reason why a proactive approach is imperative. We urge you to view any reform measures through the lens of historical prejudices and biases. Please go the extra mile and perform a racial impact analysis for any contemplated reforms. This important step will truly move us closer to the ideal of a nation with liberty and justice for all. And I thank you very much for this opportunity to share our observations and for all the work you do, including that substantial data set which you make available readily on your website. I look forward to addressing any questions you may have.
Thank you very much for your testimony. Any questions from any of the commission members? Anyone, any commission members online have any questions? All right. Thank you very much for your testimony. We
Okay.
appreciate it.
Thank you very much.
All right. Next up will be Sean McCormick, now of the Cumberland County District Attorney's Office. I guess we've been at it a long time because when I was in Montco, you were in Dauphin.
Yes, good afternoon.
Good to see you again.
Yes, good to see you also. I want to thank you for allowing me to be here today and for all of you taking the time to not just work on this and then present it to the rest of us, and we all have to deal with it. We appreciate the opportunity being given to us to comment and perhaps give some comments that you'll be able to use and make a system that is indeed fair for all involved. By way of background, for those of you who do not know me, I am the Cumberland County District Attorney. I have been District Attorney since January 3rd of this year. Prior to that, I was in the Dauphin County District Attorney's Office for over 30 years. For about 25 of those 30 years, I was the chief of our child abuse prosecution unit, and I specialized in child abuse cases. I've also chaired for many years the District Attorneys Association's Child Abuse Coalition, which is a group of prosecutors from across the state that specialize in child abuse cases. One thing I did want to say here today, in my new role as a district attorney, something I never worried about when I was a line prosecutor, and that is the impact that the changes will have on the staff in my office. It was something I never thought of. I would complain as I sat down individually having to put together the guidelines. But our office is an office that I have 3 individuals in my office who pre-trial, before arraignment, put together our files. And one of the jobs that they have is to prepare the sentencing guidelines. And I know you've had comments from at other hearings concerning this, but I wanted to just very briefly emphasize the impact of the up and down OGSs and the prior record score calculations. I am not against those changes, but I ask you to take in consideration the impact that some of these changes and the more complicated we make the sentencing guidelines from that perspective, the impact it's going to have. I do not imagine that my county commissioners are going on a whim, say, oh, there's new sentencing guidelines. You have 3 or 4 new people to help calculate them. I've been told a number of times that, a lot of the changes we're looking at are kind of the way that the federal sentencing guidelines are currently set. Well, keep in mind that the federal guidelines are calculated by the Federal Probation Office. And that is something they've been doing for many years and are staffed to do it. We are not. And, whether it be a probation department in a county or a county DA's office putting these guidelines together, it's something I ask you to please keep in mind. The thing I wanted to mainly focus on today is really the area that I know the most, and that's child abuse cases and sex assault cases. And one of the things that I ask you to take into consideration as you look at these guidelines and take all the comments you've been getting from across the state is the lapsing provisions. I am not against lapsing. In fact, there have been many times over the years where I have been looking at sentencing guidelines and looking at an individual whose sentencing guidelines are so high because of something they did 10, 15, 20 years ago. And I've sat here and said to myself, this is ridiculous. This person, this is so stale. This is so old. This is a situation where we should be giving the person a break. So in principle, I'm actually in favor of the concept of lapsing. What I ask you to consider are something that I'm calling like a carve out, something for particular crimes that are related to the crimes that might be a little older, consider calculating those into the prior record score. To give you an example, if someone is charged with a sex crime, whether it be rape or let's use rape as an example. Someone is charged with a rape. 20 years ago, they had an M2 indecent assault, maybe 2 or 3 M2 indecent assaults. I think having a prior crime that is related to the crime that they are currently being sentenced for is an important factor that the court should be considering, and it should be factored into the sentencing guidelines. We talk about the fact that, well, courts can aggravate a sentence. If a court wants to aggravate a sentence, they can aggravate a sentence. It's not that easy, especially those of you that are judges know that it's not that easy, that when you depart from the sentencing guidelines, we have appeals, we have all sorts of things that we have to deal with. And many times cases are returned to the court for departing from the sentencing guidelines. And there's many reasons why that happens. But if we were to factor those things that are related to the crime for the defendant that is before the court, the person that is before the court, I think that is a factor that really should be considered. And I think in many ways, when I'm talking about sex assault cases, I'm also talking about intimate partner crimes. Those types of crimes, along with sex crimes, tend to be historically underreported. I have prosecuted many people over the years, and I can think of one right off the top of my head, a man who I prosecuted back in the mid-1990s. I've been around that long, who I prosecuted in the mid-1990s. And then he disappeared and he did his time in jail. And it's 20 years later. 20 years later, he finally pops back up. Was he crime-free during those 20 years? No, he wasn't. We wind up eventually prosecuting him and uncovering 8 different victims over the years, but they were not reported. They were not investigated. He had no convictions for those. So when he goes before the court for sentencing on that new crime, if we were to erase his crime from 1996, the court isn't getting a fair picture of this person. He was not crime-free for all that period of time. when we're talking about lapsing provisions, are we considering the fact that, well, was a crime committed back a certain time period, not the conviction, but the crime? Was a crime was it committed in 2010? He wasn't convicted of it in 2010, but was he committing crimes in 2010? And I think that's something to consider. And I'm not looking, because I just spent time complaining about the complexity of the sentencing guidelines, and I'm actually suggesting something that might add to that complexity. But I think it's an important thing to think about when we're thinking about crimes against the person. When you have crimes against the person, and in the past you have crimes against the person, to consider those crimes in those circumstances. If the person had an indecent assault or an aggravated indecent assault 25 years ago, and now they've been arrested for a PWI, yes, I don't think that the 25-year-old crime should be considered for the PWI. But for the specific crime that is related to why the person is before the court, I think it should be. And I ask you to please take that into consideration. One thing that I also ask you to do when looking at the revisions to the sentencing guidelines, we spend so much time, and we do it too as prosecutors, spending time looking at the individual who committed the crime. Please do not forget the individuals who are victims of the crimes. They deserve justice in court just as much as the defendant deserves justice in court. We cannot forget the victims. We cannot become so focused on the individual who is committing the crime that we forget and we lose sight of the victims. I was just listening, talking about, well, someone might for 2 to 16 times take to go through treatment. But if they're committing 15 more crimes, there are potentially 15 more victims along the way. And we have to ask ourselves, at what point in time are we saying enough? Again, just something I'm asking you to consider when you're looking at these things. That's pretty much the major focus. I don't want to take up a lot of your time. I had some other things I wanted to mention, but they're the main things I wanted to mention here today. And I thank you for the time to allow me to say those things.
Thank you. Thank you for your insights. Just one, and we've heard, as you mentioned, from several of your colleagues about the challenges in implementing the guidelines, but at the same time, kind of as you alluded to, folks are actually asking us to maybe get a little bit even more granular and really, I think you put it, making things a little bit more complicated, which obviously will only add to the burdens on your staff. So as we try to balance that, do you have any suggestions or thoughts on how we do that? I mean, in order to make the guidelines, more granular so that each crime is more specific to that particular offense and that particular offender, it's going to require a deeper dive from both sides, right? From the prosecutorial side and the defense side. Any ideas, how much weight should we place on the staffing demands, and what considerations should we give to try to balance those two?
I mean, obviously that's the tough question.
So I'm asking you.
Yeah, I know. One of the things, just as I look at it, as I look at this chart, and I'm impressed with it, but is it 42 different offense gravity scores? When you talk about, you -2 perhaps if someone was cooperative. Well, what's the definition of cooperative? And how do we figure that out? And at what point do we figure it out? Because sentencing guidelines, and again, I've never practiced in the federal system, so some of this is just things I've been told, and I could be wrong, but a lot of times those guidelines are really calculated after the person's been either pled guilty or found been convicted. And then there's the calculation that's done in those guidelines, and it's probably a good pre-sentence investigation that is taking place. We utilize the guidelines much more upfront. When I go to a preliminary hearing and I'm meeting with a defense attorney, I'm trying to figure out what are the guidelines going to be. So what kind of sentence are we going to offer the defense potentially? Because we survive by way of working out plea agreements. We cannot survive, especially in a county like mine or the county I came from, Dauphin County. We're way too busy to litigate every case. We have to come up with plea agreements. So I don't know if there is a way to perhaps simplify some of the factors with the pluses and the minuses, eliminate some of them. That would be helpful. You know, one of the things that I also fear, and I'm sure it's been mentioned by some of my colleagues, is does this mean we're going to be fighting pre-sentence hearings over the guidelines? Right now, I can't think of really any cases that I have in recent memory where we've been fighting over the guidelines in court. Whether something is or is not a plus or a minus, I would, if we are going to do it, ask you please to, as best you can, define those terms. Define them as best you can. Give us something to help us interpret these things. When it's kind of wishy-washy, it's hard sometimes to do that.
Yeah, we heard that quite a bit at the Bucks County hearing, where some of your colleagues testified. And at that point in time, I did just sort of point out that right now you can get credit for cooperation, but there's really no definition for that either, or how much credit you should get. So the goal here really was trying to do exactly what I think you're asking for, is, you know, provide some parameters and some guide rails. I'll let some other members of the commission. Anyone else have any questions or comments?
Mr. Chair, this is Judge Tucker. I do have a comment or more of a question. First of all, thank you very much for being here and your strength as a prosecutor for all those years. It kind of brings to mind when I started practicing in '75 as a prosecutor, and the toils and things that we had to go through back then. And nothing really has changed. But my question to you is, you seem to make a distinction, at least I picked up a distinction between crime-free and conviction-free. What's the difference? Is obviously the difference is a conviction, as opposed to someone said that a person did something and that was a crime. But how do you get to the end of the road where you're saying that the person is not conviction, or the person is not crime-free because he did such and such? And how do you calculate that into whether or not that should be added on to a conviction?
One thing that I might look at is the date of the offense. So if the person's being convicted, like the example that I gave was a man who was over a period of time still offending on children, but he wasn't arrested until sometime in the late, 2016, something like this, some time frame like that. Over 20 years from when I originally prosecuted him, but many of the crimes he committed were dated back. In fact, we had to go back and file under the old statutes in many occasions. So in those instances, I think if the person committed the crime back in that time frame, if you were to still have a lapse for those particular crimes that are related to the crime they're before the court on, and I'm actually advocating that you don't lapse those particular crimes. But if you were to do that, at least look back at the date of the offense.
So are we talking about the date of the offense that resulted in a conviction or not?
In the new conviction. I mean, it's way too difficult to say, well, this person's been doing this, but if they haven't been convicted, they haven't been found guilty beyond a reasonable doubt at some point in time, you obviously can't calculate a crime they haven't been convicted for.
Okay, that was my
if I'm
point.
understanding what you're
That's what I
saying.
was trying to get at.
Okay.
How do you say a person has not been crime-free if there's no conviction of it?
No, and I agree. I think we're both saying the same thing. I may have or maybe not as eloquently explained my position. But certainly I'm talking about a situation where a person has committed a crime in that time frame, but wasn't in child abuse cases, and maybe these cases are more unusual. We have such a large period of time for the statute of limitations for so many of these cases. We routinely deal with people who may have committed a crime 10 years ago, and they're being convicted today for something they did 10 years ago. What I'm asking you to do is if there is still a lapse provision for similar cases in the past, at a minimum, date it from the date of the offense on that new conviction.
But you do agree that it would have to be a conviction, not
Yes.
simply an assertion of person committed.
Absolutely.
crime.
Yeah, I absolutely agree with that.
Okay, thank you. Thank you very much.
Any other members of the commission have any questions or comments? Judge Marsico?
To that end, you're talking about somebody that 20 years ago was convicted of rape, now has a new charge, but also includes charges committed within those 20 years. Is that right?
Yeah, I think I'm talking about two things, actually. The one thing is what you just said. I'm talking about somebody who in that intervening time period actually was committing a crime, but it was undiscovered.
Right.
And now it's been discovered and they've been convicted of that. The main thing that I'm asking for is not to lapse, to carve out those particular crimes. If the crime, and I'm talking about crimes against the person, if those crimes in the past are that type of behavior, I think it's informative to the court. And I think it's important to take those crimes into consideration when sentencing the person on a similar crime now.
So it's been my experience, and maybe I'm wrong, you've had much more experience with sex crimes than me. A lot of times sex offenders through the years have not gotten parole from the board, probation and parole, serve their maxes. Have you seen people get convicted, maybe serve 10, 20 years, get out, and then commit new offenses shortly thereafter? So if they were in jail for 20 years and we had a lapsing provision that say was 15 years, those would lapse. Is that something that happens?
Oh, yeah. Yeah, and I've seen that. And one of the things I also noted previously, that we do track those things already. There was a comment as concerning this is complicated to track whether a person was in jail, was not in jail, and keep track of that. We do that with crim and falsity. We have a 10-year look back. If we want to introduce crim and falsity, if the person was incarcerated, the time that they were incarcerated doesn't count towards that 10 years as to whether we can use crim and falsity or not. So there are situations where we are able to do that. And I think it is possible. And I think if someone's been incarcerated, that should not be time of incarceration should not count towards the lapsing.
You good, Judge? Right. Judge Bernstein?
Very briefly, there was a lot of discussion also. I was at the site at Duquesne University. We heard from two separate district attorney's offices there, and they raised the same concerns because diversionary programs, which actually are something I think a lot of people would be advocating for, require the calculations very early on prior to the preliminary hearings down there. And so that was, for me, something I hadn't considered. Their suggestion was maybe just make a checklist for judges at time of sentencing. And we discussed the pros and cons of that. And I'm just throwing this out as an idea. What are your thoughts on something where some of these step ups and step downs are objective, something that can be determined and others are subjective. So maybe define those out. Just as again, as something to throw out, do you have any opinion on that? Maybe part of it's determined as a calculation and others are left a determination of sentencing for the judge.
No, I actually like that idea.
All right. Any other members of the commission have any questions or comments? Thank you very much.
Thank
Appreciate
you.
it.
I appreciate the time.
All right. Next up, Jennifer Selber from the Office of the Attorney General. Good afternoon. Nice to see you too. Thanks for joining us.
I feel like between DA McCormick and Judge Bernstein, I don't think you guys have covered everything that I was going to say. Thank you for having me. I run the criminal division for the Office of Attorney General. I've been doing that for the past 5 years. The 18 years before that, I was with the Philadelphia District Attorney's Office, at that time the homicide unit, and I was with that unit. Thank you all for giving me the opportunity to speak. Put so much work into these proposed guidelines. It's a big job, very impressive work, very thoughtful, and I think we all really appreciate your soliciting so much input and feedback from different law investment partners. 2 areas of concern I wanted to focus on, which are important to my office, are the felons not to possess firearms, 6105, and I'll touch briefly, although DA McCormick covered it exhaustively and very well, the sex and domestic crimes against vulnerable victims, which my office takes great interest in. 2 quick points before I address that. Number 1 was just suggested by Judge Bernstein, which is, I think, removing that cooperation piece out of the OGS and to the discretionary part with the judge will avoid a lot of problems. Cooperation inherently is something that happens right up to the point of sentencing. Prosecutors and defendants often agree to delay and defer sentencing for substantial periods of time so that the defendant can get the full benefit of his cooperation. And cooperation is something at any time. Someone can be cooperative at the beginning and then end up lying or getting arrested again, or vice versa, could be uncooperative in the beginning and could have a change of heart along the course of the case and begin cooperating. So I think you're creating a potential litigation issue, as DA McCormick suggested, for something that really, I understand the committee's desire to want to reduce that judicial discretion somewhat by creating all the OGSs. But I think that one area of cooperation is just going to create many more problems than it solves. So I think if you separate that out, most DA's offices are still going to have some operational challenges, but that I think that will be taking a major lift off of them. And I think it will be more fair for everybody, including the defendant ultimately. Secondly, the lapsing provisions. I'm going to talk a little more about it. I really actually liked what DA McCormick had to say and would expand it a little bit, but we would advocate for time in custody not counting towards crime-free. Prison is a very different environment. That's why we don't want people to go to prison unless they have to. It's extremely structured. And if you look, for example, at sex offenders, you're just not going to get a picture of how the person is going to be without restriction on the outside. And to wipe that away without really any information is dangerous and puts public safety at risk. Moving on to 6105, I want to say generally that we commend the goal of modifying the prior record score to address racial disparities by not making it, and completely agree with the commission that we really need to focus on the offense at hand and the rest is background. For 6105 felons in possession, well, let me just say this. However, where the old and new offenses are for crimes against people, and I'm not using the Title 42 crimes of violence because I think that's actually overly narrow. Now, I'm talking about child abuse, talking about domestic violence, I'm talking about witness intimidation, certainly gun cases are crimes against people or threaten the public. And I think everyone benefits by a more specific, closer look at them, including their entire history, and not letting that drop away. 6105, felons not to possess. Targeted prosecution for 6105 is one of the most critical tools. for law enforcement to address gun violence. Enforcement experience shows that convicted felons that illegally secure firearms are the cohort that is most likely to use them on the streets. And once the shooting begins, we've missed an opportunity. And I believe the legislature recognized this. I don't know if it was 6 or 7 years ago. Representative Stevens, you may have spearheaded this effort, but we increased the penalty for 6105 in recognition of the important role that it plays. And just to explain that a little bit, why is 6105 so important? If you look at violent crime, and I'm talking about non-fatal shootings and homicides, these are the cases that have very low clearance rates because of witnesses being uncooperative, being terrified, potentially being intimidated. In a city like Philadelphia, non-fatal shootings have a clearance rate of hovering around 6%. So we're missing 85% of the shootings. So with numbers like that, it's hard to make the public safety impact that we would all want. And 6105 is a piece of that solution. It is often the best and strongest charge that will impact gun violence. Under the current guidelines, a felon in possession of a loaded gun who is a refill would have a range of 84 to 102 months. Under the draft, that same felon is looking at 64 to 66 months. So that's about a 35% decrease. I think that standard range, I know you analyze average sentences to try to create that uniformity and consistency. I think that's a great idea. But we have to be concerned about the group at the top end of that guideline. And we have concerns in many of the violent crime cases that top end has dropped off, and we will be missing the very cohort that is committing violent crimes in our community. And while we agree completely that there are many people that never have to see the inside of jails, even though they have committed crimes, many people, most people, we do have to be prepared to deal with the small percentage that do. Juvenile lapsing is problematic in this context. Urban violence is a crime of youth. Unfortunately, both perpetrators and victims are in their late teens and early 20s. So to have all the VUFA charges drop away by the time the defendant is 25, which I think is what would happen, creates an issue. If a 27-year-old man shoots someone or commits an armed robbery, if I were the prosecutor and if I were the judge, I would want to be able to look and consider the two convictions or adjudications had when he was 17. If he was 28 and committed a rape, I would want to look back and consider the misdemeanor strangulation, the indecent assault. These are misdemeanors, but the M before the crime doesn't make it irrelevant or unimportant. And again, back to what the commission said, it's the crime at hand that should trigger that type of wholesome look back. Because now we're not worried about the prior records for kind of over predicting violence, which is a problem, I think. But that violence has come to within defense. So once that falls away, you're really looking at now we are in a situation where we have to make difficult decisions and think about public safety. And at that point, I don't think we do a benefit to society by whitewashing the past. For sex crimes, as DA McCormick very depthly said, these crimes are systematically underreported, delayed reporting, under-prosecuted, unsuccessfully prosecuted, and pled to misdemeanors very frequently because of prosecutors dealing with child victims, traumatized victims, not wanting to. And so often repeat offenders then in the sex crimes and domestic violence arena are already facing artificially low and masked criminal history. We can't do anything about that. That's a systemic problem. I think that our society has come to realize the gravity of sexual violence and domestic violence. But some of these draft proposals reinforce those societal problems. And again, the lapsing provisions are very problematic because of the importance of these misdemeanor convictions. You can have very serious sex crimes and domestic crimes that end up as harassment, simple assault, reckless endangerment, and they are very important to be considered. And in the juvenile context, they're very important. DA McCormick mentioned, and I think a lot of groups have talked about sort of carve-outs for sexual offenses for the reasons we've all discussed. And I guess I thought about it a little bit differently, which is, again, the committee wants to reduce the impact of prior record score, so it is not creating a disparate impact in terms of race, and is not over predicting risk. And those are two, not just laudable, we must do that. That's of crucial importance. If someone commits a retail theft today and committed a violent rape 15 years ago, as the prosecutor, or if I were sitting as the judge, I don't know that I would be that rape. It's a horrible crime, but 15 years have gone by. He hasn't committed any more crimes of violence, and the new crime is a retail theft. And even under these new provisions, he is going to be at a higher prior record score because of a past crime. And I think there's some problems with that. On the other side of it, if someone commits a rape or an armed robbery or is a felon not to possess a firearm, then we really care about the violence or the threat to public safety has come to fruition. And now we have to talk about creating a sentence that's going to be fair to the defendant, but is going to, as in the most fulsome way, assess the risk going forward. And some of these provisions, lapsing and sort of lapsing and falling away in that context, is concerning and potentially problematic. And I don't know if you've considered this, and it's not easy to do, but I would say the crime at hand should be a factor in how we look back. And I like the way DA McCormick said it, particularly if the crimes are similar in some way. You have a VUFA and a robbery, or a rape and an indecent assault. That tells an important picture to the judge. So I don't know if that is something that could be considered, that we really do what we need to do for the nonviolent crimes and not have that be overly punitive and not have people past, drag behind them. But when the new risk is in the present, we take a hard look at that and look at everything. Last thought is just for many of the violent crimes, the top range of guidelines are reduced. I know that's been discussed. That, again, I think I completely understand what the commission was getting at and trying to get to average. I guess our concern is non-average, because I think that does the job for most of the people that come before the court. But judges understandably do not like to sentence out of the guidelines. They don't like to make an aggravated sentence. And there's concern that for those defendants that are, albeit a small number, but a very impactful number, a dangerous number, that judges are going to be very dissuaded from sentencing. And thank you. Happy.
Thank you for your insights. Really, really helpful. Thank you. Just a question, and it's a follow-up to something that I asked T.A. McCormick. So, for example, one of the crimes that we looked at, I think you mentioned that when building these guideline ranges, our staff really tried to keep the new ranges to be reflective of the actual sentences that are being handed out today. I was really surprised to see for the felony drug offenses, the heavier weight offenders were receiving very significantly lower sentences than the guidelines actually called for. As we thought that through, I believed it was largely due to cooperation, that, they were obviously folks that wanted to cooperate because of the heavy sentences that they were facing. And therefore, that's why we were seeing across the state. And as you mentioned, most of these cases are resolved through pleas. So across the state, we were seeing these departures below the guidelines. That's what drives it. I can only speak for myself. The desire to, in some way, shape, or form, provide some guide rails or definitions for what is cooperation and what should you get for your cooperation. As a commission, we're a data warehouse. I mean, we collect all this data and it's really helpful, but that's an area where we are really blind right now in terms of, and frankly, practitioners are blind too. A defense attorney doesn't know what his client needs to do in order to get X departure from the guidelines. And a prosecutor doesn't know, what to seek as it relates to a particular offender, based on their level of cooperation. And so we end up with these disparate sentences, in Blair County versus Erie County versus Carbon County, where the same cooperation might yield completely different results because we have no guide rails. Can you speak to that a little bit? I mean, do you have some thoughts there as it relates to your testimony about sort of eliminating the departures on cooperation?
I mean, first of all, I would say, I think that's an excellent true, but that same sentencing disparity, at least I've seen now that I'm statewide, I really see is very geographically. So there are wildly sentences. One of the things, wildly different sentences for drug conviction of where you get arrested in the state. So the difference on the cooperation side is less than that. I mean, there's definitely, you're some places you're really rolling the dice. You could end up with a huge monster sentence that you wouldn't get for a violent crime somewhere else. So I think that needs addressing by the commission. But I think cooperation, first of all, because, you could have factors for the judge to consider, like, I mean, primarily whether the defendant is a testifying witness, or whether just could definitely put categories, far too different categories. But if the other case ends up pleading, you don't want to take away, let's say you have a defendant that is willing to testify against a co-defendant. As a result of that, the co-defendant pleads. You now not give the defendant that benefit. He was prepared, and maybe he was even the cause of the defendant pleading. He should get that benefit. So I do feel like a lot of that is between the prosecutor and the defense attorney, and I see it as being less problematic in the cooperation area than I do in the regular drug case going to verdict sentencing. But I do think those are that you could think about factors such as, when they cooperated, whether it was right away or after the hearing or a year later, and whether or not they were.
That's great insight. Thank you. Any other questions, comments? Yes, Representative Krajewski.
Thank you, Chair. And thank you, Ms. Selber, for your testimony. You ask about when you had spoken about wanting to be able to consider past convictions that were in the lapse period. It seemed as though you were specifically were focusing on violent or sexual crimes and considering that. So is that specifically what you're referring to, or are you considering all prior offenses when having that consideration?
So we're focused on new crimes against people. So again, it's a little bit broader than the crimes of violence in Title 42, but new crimes against people or threat to public safety, looking back at similar crimes. So again, the retail theft from 1990 is not relevant to the rape of 2020 and vice versa. The rape of 1980 is not relevant to the retail theft. So there is, as Dave McCormick said, there is something about those like crimes, the willingness to harm others or threat to public safety that warrants a broader look.
So you're like particularly concerned with patterns of continued crimes or in like sexual and violent crimes.
Correct, with the goal of giving the judge enough information to make that defendant assess public safety.
Thank you. And another just quick question in regards to the issue of gun violence, which all of us are on the commission are obviously concerned with, and in particular for myself coming from Philadelphia and a district where we are struggling with this issue. It's something that's very much on the top of my mind as well. And one of the things that I've also been encountering and trying to address the issue is, as you said, of course, there are a certain segment of people that are like repeat offenders and kind of consistently committing crimes of violence. But also in sort of trying to understand the issue, it seems like there are a lot of people who honestly are just sort of armed or may have possession of a firearm like out of self-defense and out of their own kind of feelings of safety. And as my question is, in trying to target those people who may be of that smaller segment, do you have any concerns about if that may adversely affect some of that larger population of people who aren't necessarily in possession of a firearm to commit violence, but maybe having a firearm out of their own personal safety or self-defense?
Yeah, that's a great question. So, I'm specifically talking about 6105 felons not to possess. So all of those 6106, 6108, the bulk of gun cases, that's just, possessing a firearm on the streets of Philadelphia without a license. In some cases, for some of those cases, they're misdemeanors. Sometimes they're felonies third degree, but they are not 6105. 6105 is you committed certain felonies, not even all felonies, and have illegal weapons. So that is a different cohort from the people that you're talking about, which is someone that is generally a law-abiding person who maybe is subject to a high crime area where they work or where they live and may not have gone through the steps that they needed to legally gun. And of course, the facts and circumstances around that arrest, you would imagine, would not be indicative of somebody that was violent. It was sort of a happenstance recovery. So yes, I think that's an important.
Excellent. Thank you. Those are all my questions.
Thanks. One quick follow-up I have to that. In addition to crimes that are similar, would you think that the same victim would warrant a look back as well? In other words, pick a crime, a robbery, and 10 years later, now there's a burglary. Even though they might be different crimes, the fact that they're the same victim, would you advocate for maintaining that look back?
Yes, I mean, I would advocate for that based on the type of crimes you're talking about, regardless. But certainly, any sort of pattern behavior like that, that would be a personal relationship. Sentencing judge, I imagine, would want to. Yes, definitely.
Okay. Any other commission members have questions or comments?
Mr. Chair, I do have a question. It brings to light a situation where, in terms of lapsing, we have a situation where person has in fact been sentenced, convicted and sentenced, did the time, and 6 years later, they're back for the same crime, convicted again. And of course, your adversary will say, well, they did the time. Why should the court add more time for something that's already been sentenced for, time did? What's your response to that, to the people who would voice that to you?
Thank you, Judge. Yes, I think that, one of the reasons why we punish is to affect a change on that behavior. So one of our goals, there's many goals, the criminal justice system, but one of the goals of convicting and potentially incarcerating or penalizing in some way the defendant is that he go forward and not do that again. And so it's just the fact that he did his time for the first crime does not, why would we put him on the same footing as someone that has never been convicted of that crime? He knows he did something wrong. He was caught. He was punished for it. And so there has to be some acknowledgement. And I think we see that in all walks of life. It's not limited to the justice system. Once you have been told and face the consequences of your actions, you're not, you're going to be punished in a harsher fashion.
Thank you, and pardon the big dog bark.
No worries. Judge Marsico.
I know sometimes prosecutors can, when they have an offense in front of them, manipulate what they want the conviction to be to make sure the next time the person is convicted, the guidelines reflect that. Do you think the lapsing provision might have the opposite effect, that instead of prosecutor cutting someone a break, letting them plead to a misdemeanor, now they're worried that crime might lapse, they might insist on a felony conviction for that person or something along those lines?
That's a great point. I think that's absolutely true, and nowhere is that more true than with sex offenses. I think prosecutors are often looking, again, to protect the victim. They are willing to plead those cases down in a way that they wouldn't necessarily be in other circumstances. And this would be, and yet the prosecutor is very worried about recidivism in the arena of sexual offenses. So with that, I think there is going to be a lot of concern about that.
All right. I think our executive director had a follow-up on 6105.
I did. Thank you. And thank you for your testimony. That was really helpful. It starts with the idea of 6105, but it goes to your larger point in that of the DA regarding focusing on the current offense gravity score and thinking about things like crimes against a person and course of conduct and repeat similar offenses and repeat victimization. So that sort of whole constellation of things. What the commission has been trying to do is really focus that on the OGS. And when we're looking at 6105, the commission has an enhancement for the second and subsequent and other provisions because of both the increase in the grade, but also because we have a mandate to do it. So I'm trying to figure out for 6105 if the problem for those repeat offending is that it's just the OGS is not high enough. We're not recognizing it up. Not that the structure of doing that, of sort of focusing on the OGS as the way to address that isn't the right approach. So that's the one point. And related to that is just this general issue of what you and DA McCormick talked about in terms of, maybe for certain patterns of behavior, repeat offending, we should try to look at how we can capture that to address that kind of prior as different than other priors. And I'm just wondering if the way to do that is the OGS as well. If that whole idea of course of conduct or repeat offending of a certain type or something like that, instead of all the adjustments we're talking about, just build it into the offense gravity score when those things are in place, just like with 6105 for second or subsequent, it bumps up the OGS. And then it's a matter of calibrating it to make sure it makes sense. So you move it from the prior record score and into the offense gravity score because you want it to be about that particular type of behavior. And whether it's child sex abuse or other things like that, it might be a cleaner way to instead of focus on all kinds of complications with prior record score of moving into the OGS. So I'm just trying to think about if that's a path the commission should be considering.
And I think it's possibly a path, but I would imagine a little bit disruptive what I would want to see. If I saw a gunpoint robbery or not today, I would be in all of this.
Mm-hmm.
And so that's not, those are similar crimes, but I'm not sure that that's what we're talking about. You were talking more about pattern offenses, which I think doesn't. But I guess in the way I look at it, once you're in a situation where you have crimes against a person, potentially dangerous situation going forward, then it's time to, and look, that old offense, the old BUFA might be a certain that doesn't, but the ability to take everything. I think that's the issue with a lot of the sexual offenses and violent crimes. That top end of the guidelines has gone away for the reasons discussed. And we just, again, it's a small cohort, I believe, that we're talking about, but we have to find a mechanism to capture that cohort without putting judges in the saying, I'm departing from the guidelines.
Right.
Or it has to be somehow transmitted to judges that like, we expect you to do that in these.
Yeah.
So there's a million ways to do that, but that's the idea that I all group of people are talking about. I think rules are for, capture 90%. But unfortunately, it's always that 10% that.
Well, and so just quickly, one thing is, the guidelines are about the typical sentence for the typical offender. So it does focus on that space. But I'm just wondering if, with coming up with the right definition, not necessarily what we talked about as course of conduct or that for, but something linked specifically to what you're talking about offenses against a person as the mechanism for the enhancement, that it might be a way to address whether things lapse or not, or how we treat the prior record score. It takes something very particular and builds it in OGS. And that's sort of what 6105 does. And maybe we just have to recalibrate what it is. Thank you.
All right, we have to get moving. I'm sure you do too. Thank you so much for your insights and testimony. The rest of our testifiers are going to be online, and we are way behind. So we have 29 people scheduled to testify. So if we give each person 3 minutes, we will be here for more than an hour and a half, and that's if no commission members ask any questions. And if we don't take a break to let our court reporter rest her fingers at some point. Are you okay to continue on right now? Okay. All right. But so I would ask each person testifying online moving forward here to try to confine their testimony to 3 minutes. Just really hit the highlights. We will review the written testimony. And if you could avoid duplicating testimony that we've already heard to the greatest extent possible, that would be a terrific help as well. If we can, oh, sure. Judge Bernstein has suggested, and it's a great idea, for those that would like to submit written testimony, and I think Kathy's going to kill me when I say this, but you could email your testimony to Kathy Dittman. Her email address is cwd2@psu.edu. So cwd2@psu.edu if you'd like to submit written testimony. And that's fine too. We'll certainly, consider the written testimony if you send that in. All right, so we will start with Robert Manzi, the Indiana County District Attorney, who I think is joining us via Zoom. And I think, Ryan, if you could give us a heads up when it's been 3 minutes for folks, that would be terrific. I'd appreciate your help there. All right, DA Manzi, the floor is yours. Thank you.
Thank you, and I appreciate the opportunity to speak before the commission and as well to do it here from Indiana County. I've actually been in and out of court all afternoon, so the flexibility has been very helpful. I will work as best as any attorney can work to be brief in my comments, and I'll forward testimony by email. One, I appreciate the work of the commission. I know this is not an easy task, and I'm sure the commission is being pulled in a lot of different ways. So I appreciate the opportunity to be heard. I would reiterate a lot of the comments I heard from Attorney Selber this afternoon. One of the issues that we're seeing from Indiana County is many of the terms in the guidelines are undefined. And I know that that's been said before, and we would ask that there's some help with defining on what that is, as we would anticipate that turning into a lot of litigation when our courts are already at capacity. The predictability of an outcome, there's many times where we're working at a preliminary hearing and myself or one of my prosecutors are able to talk to the victims and say, here are the guidelines, they're easily worked out. You can expect the sentence roughly here. With the many mitigating and aggravating factors that works into changing the OGS, it then turns into providing a much wider net and a little bit of less predictability, which our victims are really looking for when they decide to agree to some terms of an outcome. And that predictability, we've talked to our defense bar here, and they've raised some of the similar concerns in a district court, they can say your guidelines, we anticipate being here. Now it would be, we anticipate being here, and then it's really going to move up and down a great deal. One of the things about capacity we talked about, we attempted to run the guidelines on some cases we have here. And I do believe that not only are we going to be looking at a lot more hours to run guidelines under this new system, and when we ran them, we had a lot of times where we would time and it would be significantly higher. I do believe that as people get used to working them, it gets easier. So I don't know that any times we're running now would be true. It would have to be a little less with familiarity, but we're going to be looking at more staff need to be hired out of our probation departments to be able to run these. Secondarily, we're already litigating it at preliminary hearings and at court. We fully believe that there's going to end up being a lot of litigation on guidelines here. And when we look at capacity issues, we wonder how many times there's simply going to be deference one way or the other just to not worry about appellate issues. So there's obviously some concerns there. I'm a research person. I like to try to read research when I can. And I know with the lapsing, when we have low-level crimes lapsing, I don't know that there's a great deal of concern with that. In fact, many offices already look at it and we'll say, hey, we'll still do an ARD on a DUI if you've had it before 10 years before. So it's already functionally happening certain times now. But the research also talks about the predictability of criminal behavior based upon current offenses. And right now, when you have a person who's convicted of, let's say, 3 or 4 cases right now, and they're pled and they're sentenced on the same day at the same court, it doesn't have the same effect on that person as it would a person who maybe has the same amount of cases, but in different counties, so they're sentenced on different days. I would hope that as we're looking at using priors as predictabilities, we would follow that research and say, we're going to be looking at all of the current offenses. And, just because you happen to be sentenced on the same day, we should be looking at that as predictability of current, future offenses. The inchoates being reduced simply because it's an inchoate, that is definitely going to turn, I know, my office into looking at some of the offenses. And quite frankly, we have cases where you're looking at dealing with what the defendant's intentions were. And somebody who was, we just recently had a case here in Indiana County where there was an attempt to meet a child 13 years old for sex. And because of good policing, we were able to stop that before it really came off the ground. But now that's a criminal attempt. That person there had the same intentions as somebody that happened to got through. But then they get treated a little bit less with having those same intentions. So there's obviously a concern that there's almost a reward because you got caught by police because you could get there.
Thanks so much, DA Manzi. We need to get moving on to our next testifier. So if you could wrap it up for us, please, we'd appreciate it.
Certainly. And lastly, again, I like to follow the research. And I think one of my big things is predictability of outcomes and capacity, as well as making sure, while we might be not considering offenses 20 years ago, that we are able to truly look at what an offender is doing nowadays with multiple offenses that are sentenced on the same day. Again, I appreciate your time and thank you.
And thanks so much. And I apologize for having to cut you short. We just have an overwhelming response that we need to get through here. So if you please send us written testimony, we will certainly make sure we include that and consider that as well.
I will do that. Thank you for your time, everyone.
Any questions or comments from any of the commission members? Any of the online commission members have any questions or comments? All right. Thank you so much. We appreciate your time and your insights today.
Thank you. Thank you, everyone on the commission.
Thank you. All right. Next up is Maria Gelner from FAM.
Hi, good afternoon. Can folks see and hear me?
Yes, we can. Thank you.
Fantastic. Good afternoon. Thank you. Nice to see you again, Chairperson Stevens and all. Thank you so much for having us. Maria Gelner, I'm the Pennsylvania State Policy Director for FAM. FAM is a nonpartisan advocacy organization. We work to create a more fair and effective justice system, both respecting our American values of individual accountability and dignity, and also keeping communities safe. Thousands of Pennsylvania families support FAM. I am here representing them today. I am not here as an individual. I am representing thousands and thousands of Pennsylvania families from all walks of life, rural and urban, white, Black, Hispanic, every color, every area, some returning home from prison, families of people who have been in prison, and many, many who have suffered from both incarceration and crime. Those experiences are not mutually exclusive. I would please encourage you to read FAM's report that we issued last year that is linked in our written statement called Time for Justice, the Urgent Need for Second Chances in Pennsylvania Sentencing System, where we focus on and analyze extreme sentencing in Pennsylvania over the last 40 years. We have the dishonor of being a national leader in extreme sentences, which we looked at as being sentences of 20 years or more. And our state prison population has been shaped by some of the harshest sentencing laws in the country. As of this morning, we have 36,000 human beings locked in small cells in our state prisons. That is 36,000 families affected on the small end. And you all know that that doesn't include county or federal prisons. The DOC budget this year is well over $2.5 billion. And it's very, very important for all of us to understand and really internalize that this rise was driven by punitive policy choices and not by crime. And our report lays that out. So please read our written statement and the report. Over and over again, we see that it is not harsh sentencing that deters crime, but the swiftness and certainty of punishment. So I am here saying today that more of the same is not going to get us a different result. It is not going to make Pennsylvania safer, and we cannot continue to do the same thing over and over again. We do thank you for all of the positive steps that each of you have taken. I have personally been exceedingly impressed in my review of this commission's work. I know that each of you, whether we agree or not on the policy points, each of you works very, very hard. And thank you for what you are doing on this body. Those specific compliments are laid out in our written statements, so I will jump to some of the points that I think haven't been made today. I would ask the commission to consider even more heavily than you already have, including the input of directly impacted people and families. I was struck in reading the requirements of who has to testify or be given the opportunity to testify today, that 7 of the 12 groups enumerated in 42 Pennsylvania Statute 2155 are law enforcement or law enforcement adjacent. I really applaud you for seeking and getting the input of incarcerated people, but that should be enshrined in law that directly impacted people and families get input. And also in your working groups, in your stakeholder groups, we ask you to give directly impacted people proportional representation. For the most part, we do support the requests that were elaborated by Marianne Stein of the ACLU. Some of those specifics, which I think are not fully identical, but in large part we support most of what she indicated today, and our specifics as to the guidelines are enumerated in our written statement regarding not double counting recidivist penalties, going further in reducing the impact of the prior record score. And if that requires a change to the enabling legislation, let's not view that as a permanent impediment. Let's try to get that done. We encourage you to go further in lapsing provisions, opportunities for downward adjustment, and further with restorative sanctions without probation, which is appropriate in more cases than I think most of us realize. We also would encourage courts throughout Pennsylvania and the Sentencing Commission to encourage courts to really use a uniform sentencing instrument. That is not happening throughout the state. The practice is pretty widely different, although I understand that you have the forms and the technology to do that. So we would encourage you to educate, courts throughout the state to use that uniform instrument that includes all of the options, or the checkbox form like you were talking about earlier. Earned time credit we support. And I think most of the other things are detailed in the written statement. I would just say to please not limit reforms or changes to people convicted only of, quote, nonviolent offenses. That labeling is subjective and sometimes legally inaccurate. So we know for felony murder, somebody didn't need to kill somebody or even have the intent to kill somebody, certainly second-degree felony murder is going to be labeled as a violent offense. And I'm not saying that it always shouldn't be, just that we should have case-by-case analysis for every situation wherever possible.
Thank you. We unfortunately need to
thank
move
you.
on to the next
Appreciate it.
next person. I'm sorry about that, Maria.
Okay, thank you.
We do appreciate your insights, and we'll certainly review your written testimony and that report that you linked as well. Are there any questions or comments from any members of the commission? All right. And Ms. Stein was not in the room when you commended her testimony, so we'll extend those remarks to her now since she's back here. Thank you very much for joining us and for providing your insights. We appreciate it. All right, moving on to Sarah Jacobson from the Public Defender Association of Pennsylvania.
Hello, everybody. Good afternoon. My name is Sarah Jacobson. I'm the Executive Director of the Public Defender Association of Pennsylvania. My pronouns are she and her. Thank you for letting me talk to you today. I'm going to try to be as quick as possible and try to not repeat points you've already heard from other folks. I will say that I was able to attend most of these hearings, and I applaud you for getting broad input across the state. What I heard from community members time and again in those hearings were that they wanted sentences to be individualized to the people being sentenced, but that they were also asking that sentences be lower, that there be less incarceration and more opportunities for treatment and rehabilitation. I understand that some of what the Sentencing Commission can do impacts that, not everything. But I also heard from the members of the commission and the members of the staff across these hearings that part of what you were trying to do with these new proposed guidelines was to replicate what is. And I ask that as you go forward and consider these drafts, to hear the voices of the community saying that that there's a need to reduce incarceration and not just replicate what is. I also will ask you to consider your data sources, because if your data is incomplete, then even the attempts to replicate what is in terms of the sentencing ranges can't be accurate. My understanding is that the Philadelphia municipal courts don't report data to the Sentencing Commission, and that when I look at the JJPI data reported on the Sentencing Commission website, that Philadelphia's Court of Common Pleas in 2019 reported 46% of its sentences. In 2020 reported 39% of its sentences. To me, that sounds like an incomplete data set. And to the degree that you are trying to replicate what is, if you're not including the Philadelphia Municipal Court sentences, the sentences of all misdemeanors out of Philadelphia, the data is going to be skewed. I would submit instead and ask you to either with subpoena or right to know, open records requests to get that data from the administrative office of Pennsylvania courts. I think it's there and it should be part of what's considered as you move forward. I also wanted to talk about a couple things from the offense gravity score side of these proposals. Specifically that category A, we think it's great. We think there should be opportunities for rehabilitation and programming and things that aren't jail or probation. But right now, category A almost becomes a myth because there are so few offenses that fall into category A. I ask you to take a look at those level 2 offenses. We concur that they are relatively obscure and not frequently charged. There are, I think, no offense gravity scores of 1, and there are only a handful of 3s or 4s for some specific crimes involving operating like a boat while intoxicated. We ask you to consider expanding category A, and specifically to do so by looking at the kinds of crimes that are low-level misdemeanors that are more currently charged, or more commonly charged, I'll say. Think of those misdemeanor disorderly conducts, misdemeanor harassment, low-level drug possession, low-level retail theft. A number of those are currently graded, I think, as a 5. And we would ask that you consider putting those in that range to make category A accessible to offenses that are actually charged. with some frequency. Wanted to talk also about enhancements and mitigators. You've heard from a lot of prosecutors. I was at that Bucks County hearing and hearing the prosecutors talk about the concerns about the ambiguity and the enhancements and mitigators, the concerns that the enhancements and the mitigators will add to litigation in courts and add to workloads. I'll add one other consideration that they hadn't talked about. We agree that terms need to be defined. Who decides what's an enhancement or a mitigator needs to be clear. Burden of proof for things like gang enhancements needs to be clear. But we would submit that instead that the commission only include enhancements or mitigators that are currently written into the law, as the legislature is the proper place to legislate new enhancements or mitigations. And similarly, with the places where there's enhanced OGSs for repeat offenses, again, we would submit that the legislature is the right place for those decisions to be made, and would respectfully say that those are other avenues for litigation that could be opened. Given the ambiguity.
Unfortunately, we need to move on to our next speaker. So if you could wrap it up, that would be terrific. I appreciate it.
Sure. We support lapsing. We support juvenile lapsing at age 21 and 25. We support adult lapsing. We don't think that lapsing should toll or be paused while folks are incarcerated. I'm happy to answer any questions about that. And I hope you will read our written remarks, our written testimony, which we have submitted. Thank you so much.
We will. Thank you very much for submitting it. And again, I apologize for having to cut you off. Unfortunately, we've got a long list and we've got to get through here. Any questions or comments from any of the commission members? Any of the online commission members have any questions or comments?
Thank you.
Thanks so much.
All right. Thank you very much. All right. Why don't we take one more and then we'll take a quick break? Does that sound good to everybody? All right. My understanding is Mara Dembraven is not online. So if Mara is online, please speak up because we are not seeing you there. So we'll move to Kavita Goyal from the Defender Association of Philadelphia.
Actually, I just signed up to attend. I don't have any comments. I believe there are some community members who are partners, Asada Thomas, Monica Allison, Patricia Vickers, who are all on the list. If any of them can be called on to speak in my stead, that would be great. Asada Thomas, Monica Allison, Patricia Vickers, Martha Williams, I believe are all online, and Devontae Douglas.
Okay, terrific. Thank you very much, Kavita. We appreciate you letting us know. Have we heard from Mara? Okay, let's go to Deanna Weaver, the Crime Victims Alliance of PA.
Thank you very much. I appreciate the opportunity. Can you hear me okay?
We can. Thank you very much.
I am from the Crime Victims Alliance. I'm Deanna Weaver, Program Victim Witness Services, the Program Director here at the Office of the District Attorney in Lancaster. Just as a background, CVAP was established in 2011. We're a statewide victim membership agency. We are comprised of advocates, victim survivors, and other allies who work on behalf of crime victims to address unmet needs. We collaborate with other stakeholders to make sure victims' voices are heard. So we really appreciate the opportunity to bring voice of the victims to this discussion. While, of course, individual victims are all different, and we appreciate that they have varied needs, we know that there are some common needs that through our work we have learned about over the years. Some of them were addressed. I appreciate the DAs and the AG prosecutor that addressed some of them. I just want to focus on a couple and really I'm just going to concentrate on how we think some of the proposed guidelines could affect the needs of predictability, truth in sentencing, and accountability for the offender. So keeping those needs in mind, and they're certainly elaborated in our written testimony, I'd like to address some of the specific changes within the guidelines. First, the ways we think it can positively affect. First, the consideration for pleas and cooperation. We believe that is meaningful for victims to hear a defendant accept responsibility for the crime. Cooperation with law enforcement to bring other co-defendants to justice can also be very important to victims. So we are certainly in support of that. And this, of course, pleas and cooperation can, of course, also spare victims, especially those most vulnerable victims, from having to testify at trial. It reduces the likelihood of appeals and reduces the length and difficulty of the justice process for them. Enhancement of multiple victim crimes is something else we believe could positively affect victims. We do not think that offenders should get a group discount, and it can be very frustrating when that happens. Accountability is reduced when sentences do not consider each individual victim. Now, just a couple areas of concern that potentially could negatively impact victims. With regard to lapsing, I'm not going to go into detail because I know others have. We think certain offenses should always count. Sex offenses, homicides, and attempted homicides where serious bodily injury is caused. When a life is taken or permanently altered, we think that those offenses should be treated differently. Also with repeat offenders, refels, revocs, and defendants with high prior record scores that are crimes of violence, we believe they should be set aside as they are under the current guidelines, because there's a big difference between someone who commits multiple misdemeanors, nonviolent misdemeanors, and some drug offenses versus someone who has repeated crimes of violence in their history. And this is very important to victims. It comes up a lot in our discussions when we're inviting them to comment on pleas and sentences, because they are also concerned about the safety of others and not just themselves. They do not want offenders to do this to anyone else either. With regard to the DUIs, we think that there need to be longer terms of supervision for repeat offenders and higher tiers so that they get the treatment they need, and stronger consequences for repeat offenders. And hopefully this will also reduce the likelihood of future offenses. Also, with regard to proposing community service in lieu of probation, the only concern with that is how will it be enforced? Victims are also often very in favor of diversionary programs, but they want to know conditions will be completed. So that is our concern there. And then just a need for clarification about the lapsing of priors and whether or not we would include incarceration time. We believe lapsing of priors should only include time in the community. So again, we appreciate the public comment, the process. It's very thoughtful. We appreciate you listening to all sides, and we would just encourage you to ensure that victims are always, and advocates are part of this process as you go forward in your deliberations. So thank you so much for your work. Really appreciate it.
Thank you very much. And thank you for keeping your comments to our time frame here. I appreciate that. Any questions or comments from any of the commission members? All right. Thank you very much. We are going to take a quick 5-minute break to give everyone a chance to stretch their legs, use the facilities, rest their fingers if necessary. And then we'll come back with Kelvin Carrington on the other side of the break. Thank you. All right, we are going to. It's okay. All right, we're going to resume our hearing. Going to make a couple changes here because we do need to move quickly through the remainder of the folks scheduled to testify. Ryan is going to give everyone he'll note when there are 30 seconds left, and then he'll note again at 3 minutes. So we do need everyone to stay within the 3-minute period of time so that we can get out of here at a reasonable hour. Again, we will certainly review all the written testimony. You can email it to cwd2@psu.edu. That's cwd2@psu.edu. And we will make sure that all of that testimony, the written testimony, is a part of the record, and we will certainly consider it. All right, moving on to Kelvin Carrington. We'll also, Beth Walker will be on deck. So Beth, stand by, but Kelvin Carrington, the floor is yours. Kelvin is with Participatory Defense.
Okay, I'd like to say good afternoon to everyone on this webinar. My name is Kelvin Carrington. I'm a 70-year-old lifelong resident of South Philadelphia. Neighborhood I live in has been termed a ghetto until we recently received all these new residents who have pushed up the income of the neighborhood. I always remember historically it being a slum. And for my statement, I do not believe that there's any tool you can use to predict what will happen in the future lives of any defendants. It cannot be foreseen that justice system personnel who function under sworn oaths will break the law. We have clergy and physicians who violate their oaths every day, yet we trust them implicitly because of their titles. Why? Because we look for the positive and not the negative connotations in their occupations. When we see the words poor, black, brown, especially if they are accompanied by the word school dropout or non-graduate, we think threat to society. But these same young men and women are all over the country raising the erroneously titled middle class of babies every day, while some of these upstanding citizens are making a mockery of the American legal system. You force the artificially deprived majority of citizens in this city, state, and country into untenable situations, but accept none of the responsibility. And then you tell them that they are not fit for your society. You want to convict people individually by a supposed jury of their peers, and then sentence them on some general guidelines produced by some textbook experts. As we find more and more today, we cannot get the facts straight on homicide cases at trial. So let us now try to predict the future actions of convicted defendants. I have a great idea. Let us have a risk assessment tool for every professional person, including politicians, public safety personnel, athletes, etc., set up to predict that they will live in the future without any incidents of wrongdoing. Or moreover, dare we—
30 seconds, Mr. Carrington.
Pardon me?
There's 30 seconds left, Mr. Carrington. So if you could wrap up, we'd appreciate it. Thank you.
Okay, we must stop wasting billions of dollars warehousing valuable human resources, making some private individuals rich at the expense of the greater public need. And I think by example, those who are most able and most educated when they face the justice system, they should serve the appropriate time. Thank you.
Thank you very much, Mr. Carrington. We appreciate your thoughtful remarks there. Any questions or comments from any commission members? Any of the online commission members have questions or comments? All right. Thank you very much, Mr. Carrington. We'll move on to Beth Walker, and Stacy Steiner is on deck. So Beth Walker is up now and should be receiving that invitation to join the group. And Stacy Steiner, you'll be next.
Hello, my name is Beth Walker. I am a resident of Philadelphia.
And I am speaking today as a member of Power Live Free's organization. We're focusing on eliminating and ending mass incarceration. I will submit some written testimony, but I want to say that Mr. Carrington's, what he was saying, I agree with completely. We have to get off of our addiction to punishment as a way of solving a problem. If we look at our society at this time, what we see is that using a system based primarily on punishment and not on rehabilitation and recovery is resulting only in an increase in the number of people we are throwing away. This is not the way to keep society healthy or safe. I will submit further comment by way of writing. Thank you.
Thank you so much. We really appreciate your thoughts and sharing your perspective on that, and also submitting your comments in writing for us. Any comments or questions from any of the commission members? Any of the online commission members have comments or questions? All right. Thank you very much, Ms. Walker. And we'll move on to Stacy Steiner, and Carolyn Michael Shannon will be on deck. So Ms. Steiner, the floor is yours, with Carolyn Michael Shannon up next.
Thank you very much. My name is Stacy Steiner, and I am the Director of Policy and Training for the Allegheny County Public Defender's Office. I'd like to just address a few specific issues. I appreciate so much of the work that the Commission has done in order to address the guidelines. Broad changes and sweeping changes are never something easy to accomplish, nor are most people happy about seeing them come along. But to begin with, I'd like to applaud the Commission on the idea of creating and putting in writing finally a lapsing provision for adult offenders. The reality is that many of these offenses occur before the individual becomes of age, that their mind has fully developed. We all know now that the science shows that it's at 27 years old when an individual's mind has fully developed, and therefore applying some of the same provisions that we have long-standingly applied to juveniles is important to be doing with adults as well. I'd also like the Commission to note that in effect, an individual who is incarcerated or under supervision can still commit a crime. I have represented a number of individuals in the past who, while incarcerated, have been arrested for and convicted of crime. So to say that a person will automatically be crime-free merely because of the fact that they're convicted is a misnomer. The other thing that I'd like to point out to the Commission is that there's already provisions by the legislature in statutes that create for an arena where those same types of crimes that we've been hearing about, namely sex offenses and violent offenses, even if they lapse for the purposes of determining how it would affect a prior record, would still be considered by the courts, because in effect, they would be considered either part of the habitual offender aspects of mandatory sentencings, or as far as sex offenses would go, it goes into determining what the statutory maximums are going to be. Individuals that have second or subsequent offenses in those arenas are already and are going to be considered regardless of whether or not they're counted towards the prior record score. With my last few moments, I'd like to address the adjustments. First and foremost, I appreciate the fact that there are a number of adjustments that are mandatory based upon legislation, giving a clear directive to the Commission, namely things such as the criminal gang enhancements and deadly weapon enhancements and so on. But what I'd like to ask you to consider is that when you were going through and determining how many points to add on for these enhancements that have traditionally only been a 1-point addition, why you chose to add 2 points to the adjustments in an upward area, but for the ones that are historically decreased, namely the inchoate offenses, you allowed them to remain at only a 1-point departure from the offense gravity score from the underlying offense. What I'm afraid it shows is a bias towards increased incarceration rather than decreasing the incarceration. And unfortunately, you see that continue to stem through even with the additional adjustments that, although not created by the legislature, the Sentencing Guidelines Commission feels is an appropriate avenue to be addressed as an adjustment because they've historically been mitigating or aggravating factors.
Hey, Stacy, it's Ryan. You have 30 seconds left. If you could wrap it up. Thank you.
Thank you. And with just one final note, I would also ask the court or the Commission to note that yes, change is going to be difficult. And I am sure that decades ago, when the Commission had first put forth the sentencing guidelines, the same county commissions and the same groups and stakeholders said, we can't do this because we don't have the manpower, we don't have the people, we don't have the capabilities. and we're afraid of the litigation. And yet we still powered through and did it. And so for that reason, I'm asking you not to abandon it just because we're concerned about the extra work. I'm sure that every one of us are willing to zealously advocate to make change happen in a positive way.
Ms. Steiner, thank you so much for your testimony there, and I certainly appreciate your insights. Any comments or questions from any members of the commission? Any of the online members have any comments or questions? All right, we will certainly take your testimony under consideration and include it in our future discussions and deliberations. Thank you.
Thank you.
All right, my understanding is that Carol and Michael Shannon are not online. And Adrian Perry, I'm told, is not online either. So we're going to move to Devontae Douglas. Is Devontae Douglas available?
Yes, I'm here.
Okay, great. And before you get going, Mr. Douglas, 1 second here. Mark Holden will be on deck. My understanding is Mark may not be participating either. So in the event that he's not there, Antoinette Kreiselmeyer would be up next. Mr. Douglas, the floor is yours. Oh.
Yeah. All right.
Gotcha. Thank you.
Thank you. So my name is Devontae Douglas. I'm the founder of and executive director of Kings Saving Kings and Queens. It's an up and coming nonprofit based in the city of Philadelphia. And I just want to touch on 2 points really quickly. One is the offense gravity score, which we all know are predetermined to decide the seriousness of the offense. Some of the offenses that are on there are nonviolent offenses that carry a high offense gravity score. I do recognize the task that both prosecutors and judges have of protecting the public, and that these tasks may be difficult. The purpose of sentencing is to rehabilitate the defendant to become a better individual for society. And I recognize sentencing is to protect the public also at the same time. The defendant should be looked at as a whole person before assigning an offense gravity score, and mitigating factors should be highly considered before giving an offense gravity score. The second part is the prior record score. It should be stated that a person 5 years ago is not the same person, and a prior record score should not have bearing on a current case if we are talking about a misdemeanor case. This point system can hurt an individual who has a lot going on and has tried to stay on the right path, and who has not been in contact with the court system. Both of these scoring systems should recognize that restorative sanctions should be imposed for some individuals. I recognize that crime is high throughout the Commonwealth of Pennsylvania, and that our police officers, judges, and district attorneys have to keep order. We know judges have the ability to consider sentences outside of the guidelines, but that only happens a very small percentage of the time. These narrow guidelines are going in the wrong direction after decades of mass incarceration at a time when prison conditions are at an all-time low. We should be finding more ways of finding community solutions like restorative sanctions that can keep people out of prison. We should be looking for more ways of looking at the whole person to see what will help them rehabilitate based on their individual circumstances, not just penalizing them based on a score. And I thank you for allowing me to speak and listen in today.
Thank you very much, Mr. Douglas. We appreciate your insights and perspective. Any comments or questions from any of the commission members? Any of the online commission members have any comments or questions? All right, Mr. Douglas, thank you very much. We'll move on to Mr. Holden, Mark Holden. All right, I'm told Mr. Holden is not online, nor Antoinette, nor the next individual. So we'll move to Dawn Hauser. Ms. Hauser, are you on and available?
Okay. Can you hear me?
We can. Thank you very
And-
much.
Okay, thank you so much for your patience. Thank you for making this opportunity available to me and other parents. I'm a resident of Berks County, and I have a mentally ill son who is a drug addict and is incarcerated. He's a non-violent offender. I would like progress reports to be considered for criminals the moment they become under the supervision of the probation and parole office.
Oh no, I think we may have lost you. Is there a way to get her back? Okay. So for those watching, we had some technical difficulties here, but I believe we have Ms. Hauser back now.
Okay.
Ms. Hauser, we lost you right after you said that there should be progress reports from the probation and parole departments.
Right. So I just had, from a parent's perspective, I just had terrible frustration because the probation office was not viewing my son. They told me about dual diagnosis and what that term meant, having an addiction as well as being mentally ill. But they were allowing him to kind of be the power figure in the relationship, the triangle relationship between the family and the probation officer and my son. And this was accomplished because he was allowed to not sign a waiver, which would have given me the ability to be a part of his rehabilitation. And when we went to the Karen Foundation in Wernersville, Pennsylvania, the Family Connection Day, we were told that the characteristic of an addict is, one, they're unable to keep promises. 2, they lack understanding towards others. And 3, we must look at them, they are liars. And that's a strong word, but what they were saying is that for them to be enabled to continue their alcohol addiction or their drug addiction, they must be lying to feed the addiction. And so I just would really look for some help with this waiver, especially for the mentally ill, because my son had no idea of the damage he was doing by not letting the probation officer, by not signing that waiver form. So his goal was to hide his addiction and to keep us out from helping him or even knowing his business, because of course a drug addict doesn't want anyone to know his business. But there has to be better communication between the PA disability rights or the mental health, the county mental health department with probation, with the probation office, if we're going to help the mentally ill, because they clearly are in no position to understand their own needs, to communicate their own needs, and to even see the danger. And so my son, like that one judge, I think, was talking about, my son is one who did a couple of misdemeanors, stealing. He's a thief to feed his addiction, but now he's in prison in solitary confinement for 4.5 years because he wants to be in there, because he was raped, because he was given K2 drugs. So it's true what that lady said, crimes are happening within the prison. And
Dawn, you have
yes.
30 seconds.
Okay, so I just hope that we can take a couple of steps back before sentencing day and really see there's a lack of advocacy. It's taken me 10 years, even though I've spoken to offices in Harrisburg, Philadelphia, Berks County, Lancaster. It's taken me 10 years to find out about the Criminal Justice Advocacy Support Guide. I found out about it 2 months ago. I should have been given this guide when my son was under the authority of the probation and parole office. And I'm finding it after 10 years. It's taken.
Dawn, that's over
Thank
3
you.
minutes. Thank you.
Thank
We-
you so much. Thank you for hearing my concerns on this issue.
Well, we appreciate you sharing your perspective on it, and I'm certainly sorry to hear all that you're going through with your son, for sure. Any
Thank
comments or
you.
questions from any of the members of the commission? Any online members have any questions or comments?
Just one, Ms. Hauser, I've read your very detailed letter and sincerely appreciate all of the thoughts. And I can personally tell you that I will do whatever I can to advance some of the thoughts that you have in this detailed letter. Thank you very
Thank
much.
you. Thank you for your consideration.
All right. Thank you very much, Ms. Hauser.
You're welcome.
All right, moving on. The next individual to testify would be Haslam Goodman.
Yes, I'm here.
Hi there. Thank you so much for joining us. We appreciate it. And the floor is yours.
Thank you. So I am coming before you on behalf of my fiance, who is currently in the custody of the State Department of Corrections. I'm not here to tell you what you're doing right or wrong with this. I applaud everything you're doing and just taking the initiative to correct something that's not right. What I want to say to you and show you the impact that this proposal could have on someone is a matter of decades in prison or decades home with their family. In November 2021, my fiance was sentenced to a 30 to 60 year sentence for the crime, PA crime 2502. He was arrested in 2016, took 5 years for his sentencing. In between that 5 years, he cooperated enough to hold the other 3 defendants accountable. The district attorney was able to get convictions for everyone involved, including my fiance, based on my fiance's honest testimony from beginning to end. He served time in both Montgomery and Berks County because of the situation. During his time in Berks County, he was instrumental in saving the life of a CO. He rehabilitated himself voluntarily, doing 4 programs, including the Inside Out Dad, so that he could be a part of his son's life, who was born while he was in jail. I say all that to say this: when it came down to sentencing, his attorney recommended a sentence of 10 to 20 years collectively in prison with time served. That was met with no objection from the prosecutor. She actually made it a point to drive that the convictions for the other defendants would not have been necessary without his cooperation. And the judge turned around and gave him a 30 to 60 year sentence after stating this on the record. I actually do not believe that there is an undue risk that the defendant would commit another crime. I think the man who sits in front of me is genuinely remorseful. I don't know that he is even in need of correctional treatment. This is the statement that is part of the notes of testimony. And as a result of this crime, 2502 in Cohen, I think that's how you say it, sitting at the highest level on the matrix, the sentence of 10 to 20 collectively was not sufficient because it did not meet the severity of the crime. Had that sentence been in this proposal, a 10 to 20 collectively may have even been too high of a sentence, because even at the highest, this sentence doesn't fall into the double digits. So I just want you to,
Haslam, you have 30 seconds.
yes, thank you. So I just want you to understand the impact of this proposal. And I know that it takes time to work things out, but get it done and work those things out later, because this impacts people, life, decades in jail. So that's all that I wanted to say. Everything else I'll send in writing.
Thank you very much. We appreciate your perspective. Any comments or questions from any of the members of the commission? Any online members have any comments or questions? All right. Thank you very much. I appreciate it. All right. Moving on to Donna Hill. Donna Hill will be up next, and Zakiya Sharif. will be up after Donna.
Donna, you can go ahead and start.
Hello, I'd like to thank the commission, first of all, and let you know that I have a personal interest in the sentencing. I'm a member of the Coalition Against Death by Incarceration in Pennsylvania and also on the board of directors of Let's Get Free, the Women and Trans Prisoner Defense Committee. I'd like to speak to you today about sentencing issues that affect not only my daughter and myself, but also the thousands of Pennsylvanians whom I believe receive harsh, cruel, and draconian sentences. I will be focusing on the other death penalty, which is what a life sentence actually is. In Pennsylvania, judges have no discretion and their hands are tied due to mandatory sentencing laws. Even though there can be overwhelming extenuating circumstances where the judge would like to give a lesser sentence or perhaps no sentence at all, he or she is unable to do so. There is no distinction made in sentencing between first and second degree homicides. Both the person who actually commits the homicide and any other persons associated with the homicide receive the same mandatory sentence, no matter the degree of involvement. Also, there are rarely avenues available for alternative sentencing for people who have mental health issues or drug dependency issues. Many psychiatric facilities and drug treatment facilities have long ago been shut down or extremely scarce, and people are instead thrown into prisons that are ill-equipped to deal with these issues. These lengthy sentences in Pennsylvania are meant to be punitive, and if lifers ever do overcome obstacles and are released, they are not equipped for the outside world as those with minimum sentences are. Life sentences do not serve to provide public safety and violate the 8th Amendment of the Constitution regarding cruel and unusual punishment. I can give you countless examples of this where lifers suffer increasingly as they age. But let me just tell you my own story, which isn't even as bad as some others. My daughter has been incarcerated since she was 18 years old. She is now 55 and has been inside over 37 years. She has several chronic illnesses, can barely walk at times, and had COVID-19 in 2020. I feared I would lose her. Some mothers actually did lose their children. The only way my daughter can come home is through a flawed and biased commutation system, which is virtually impossible, or if sentencing laws are changed and made retroactive. I implore you that such recommendations be made, and I won't take up any more of your time. And I'd like to say hi to Dean Rago, who is familiar with my case. How are you doing, Dean? Thank you so much again. And I'd like to thank everybody on the commission. Thank you so much.
Thank you for your insights. We certainly appreciate your perspective. Any comments or questions from any of the members of the commission? Any of the online members have any comments or questions? All right. Thank you very much, Ms. Hill. Moving on to Zakaya Sharif, and she'll be followed. Zakaya will be followed by Tiffany Peacock.
Can you hear me?
Yes, we can. Thank you.
Okay, thank you. Thank you so much. Thank you so much to the Sentencing Commission for allowing my community and I voices to be heard. I definitely appreciate your time, your attention, your presence, and your knowledge. My name is Zakia Reddy Sharif, and I'm a Philadelphia born and raised in the Fairmount, Francisville section of this city. I love Philadelphia. I am a catalyst for change in my community. I'm a homeowner of 20 plus years. I raised and educated my son in this city. I do work just outside the city limits, but I choose to stay here because I believe in Philadelphia. I take pride in coming home daily to my home here in Southwest Philadelphia. And the reason that I'm here today is to address the working draft of the sentencing guidelines. To be honest, upon reading some of the guidelines, I was heartbroken. I think the guidelines completely disregard the idea of rehabilitation and redemption. As a result, as a citizen of this city, I'm disappointed that very few of the guidelines offer restorative sentences that would help heal my community. For example, how is it that new scoring systems would score a felony shoplifter who possibly may or may not have a drug addiction or struggle with mental health along the same lines, similarly with a felony rapist? I would also like to lift up the idea of this committee placing peers on this committee. Just as groups of one's peers are used in juries for the court of law, I think I would like to see my community represented here, because though, you know, what's being done greatly affects my community. The people in my community should be allowed to participate in decision-making that directly affects our community. Representation does really matter. If this were me as a citizen of this city, I would like my community involved in the decision-making of my fate. I believe that sentencing has the power to help heal our communities and enforce restoration. My community has been greatly affected by mass incarceration and has had very little help with healing the damages that have been done as a result of the aforementioned. Have we considered the idea of sentencing citizens to emotional intelligence and personal development based off the nature of the crimes committed? The guidelines, to me, some are very dehumanizing and take away the opportunity for justice. Committee, I definitely do appreciate your expertise, your presence, and your dedication in keeping my community and I safe. I understand that the job you possess is a difficult one. I know that you all have the best interests of my community in mind. I will leave you with this quote by George Bernard Shaw: "Progress is impossible without change, and those who cannot change their minds cannot change anything." Thank you again so much for your time. I really appreciate it and allowing my voice to be heard.
Thank you very much for sharing your perspective here. Any comments or questions from any commission members? Any comments or questions from the online commission members? All right, thank you very much. We will move on to Chris Eden. Chris Eden, followed by Patricia Vickers. Chris Eden, the floor is yours.
All right, hello, I'm Chris Eden. I live in South Philadelphia, or I'm sorry, I live in West Philadelphia. I go to church in South Philadelphia with Circle of Hope. I just have a couple of things to say. This has been a very enlightening hearing. I'm really glad to have heard so many perspectives. My comments are mostly there's some observations on some contradictions I'm hearing today. First, one that I think you have some agency over, and that is some of the ways we're talking about victims and offenders, and kind of the arbitrary line that separates them. When I'm thinking about some of the weighting that goes into sentencing when we consider the victim being someone who is a child, someone who is has mental health issues, or is particularly vulnerable in some way. The other side of things, when we're talking about sentencing, we're talking about looking at a 27-year-old and thinking about what they did at 25 or 18 when they were or younger. You know, like we're still trying to figure out whether that's appropriate. So there's definitely, well, if it's a victim, then they're a child, and if that child is a perpetrator, then they're never allowed to move past that crime. Those kinds of contradictions need to be sorted out. The other thing, just an observation of the hearing today. I'm thinking back to some of the earliest conversation between our friend from the ACLU and Judge Tucker, and I think there's there's a degree of, I'll say this, there's a loss of faith, I think, not in the sentencing itself, but the institutions that we're sentencing people to. In particular, I'm thinking about
You have 30 seconds, please.
Thank you.
Yes.
So not that much can be done there, but I'm concerned that like overall the one of the things that we're sort of not taking into full account here is where we are sending people and why they aren't coming out well.
All right. Thank you very much for that. I appreciate your perspective. Any comments or questions from any commission members? Any of the online commission members have any comments or questions? All right, Chris, thank you very much. Appreciate your insights. Moving down the list here, Monica Allison. Monica Allison, you are up next, followed by Martha Williams. Monica Allison and then Martha Williams.
Thank you for giving me the opportunity to speak with you today. My name is Monica Allison. I'm a citizen of the Commonwealth of Pennsylvania and a longtime resident in the city of Philadelphia. But today I'm here before you as a mother to address the guidelines regarding sentencing and in particular, the offense gravity score. As a mother, I have been on both sides of this fence. Today would have been my son's 42nd birthday. He was murdered at 26 by a 17-year-old child. My son left behind 3 young daughters and 3 brothers. The teen that murdered my son left behind a mother, a father, and siblings. Both families lost sons that day. From the research, we know that brain development is not completed until a person is around age 26. And this research isn't taken into account in the system of sentencing. I tell my story because the damage of that day continues to wreak havoc in the life of my family. My youngest, who was 12 at the time of his brother's murder, attempted suicide several times and is now in county jail waiting for trial for a second aggravated assault. Offense gravity scores essentially force people to be sentenced again for crimes committed in their past. There's no flexibility to lower their scores unless they're cooperative with the law or they give up their right to a fair trial by making a deal. Where's the evidence that this form of sentencing creates better outcomes? Each case should be seen and stand on its own merit without looking at prior cases. In our city, I know I'm not unique in my experience. Profiling based on race, age, vehicle type, all breeds contact with law enforcement and the judicial system, especially in urban areas. We know that until investments are made in people, whether or not they have a criminal record is the only way out of this cycle. We know that study shows that 90% of sentences fall within the existing guidelines, and we are asking that not be the norm. As a mother, I'm asking that our children be seen as people, whole people, with all that comes to that. Thank you for allowing me to testify before you.
Thank you very much, Ms. Allison. Any comments or questions from any members of the commission? Any online members have any comments or questions? All right. Next up will be Martha Williams, followed by Asada Thomas. Martha Williams, followed by Asada Thomas.
Hi, good afternoon. Excuse me, everyone. Thank you for having me this afternoon. I have some questions that I would like the commission to consider before making the important decisions in regards to the citizen proposals today. And I'll just start with introducing myself. Again, my name is Martha. I am the block captain. On my block, I live in the Strawberry Mansion area of Philadelphia, which is a neighborhood that is heavily impacted by both victims and offenders. So here we see this is a community, a whole community that is impacted on both sides of these issues. And so my questions when it comes to sentencing are as follows. How does the community become included in the process of the revision of the sentencing guidelines? And how is the community impact of mass incarceration considered in the structure of the guidelines? And how is this data measured? And how does the community access this data? And I would also like to know how the ask of participants behind the walls carried out so that their valuable input could be considered. Who was asked to speak on February the 28th, and how will others be afforded that opportunity? And since the law requires that this data about impact on incarceration be analyzed, we would like to know what analysis was done and if it will be available to the public. What measures do you plan to ensure fairness in the process so that community input is aligned in the structure? Families in
Martha, 30 seconds, please.
Families in this community and abroad are suffering from unfair practices. Individualized mitigating circumstances are not considered in the current structure unless they plead or cooperate with law enforcement. This does not give enough range for judges to make fair rulings on cases on a case-by-case basis. We know judges can make judgments outside of the guidelines, but that only happens on very few cases. So that structure you propose will restrict 90% of sentences, causing more overwhelming harm to the entire community. So I just ask that you consider these questions going forward and be more mindful of community input, and appreciate you for allowing me to speak today.
Thank you very much. Thank you for your insights and questions. Any comments or questions from commission members? Judge Bernstein?
Yeah, just briefly, because you had asked about a lot of information, and there is a Pennsylvania Commission on Sentencing website that has a lot of that information that you're asking for and data, and also a lot of our, I guess, all of our meetings are recorded. And so I think probably Mr. Myers could speak to that more, but there is a tremendous amount of materials that would be available to you because you'd asked that question. And I think it's a great question. And I just wanted you to know those resources are available.
That's correct. We have plenty of information available on the website. We post all of the commission meetings to YouTube. So if you'd like to watch those, you can. And we also live stream commission meetings. Thank you.
All right. Any other questions from commission members? All right. Thank you very much. Moving on to Asada Thomas, who will be followed by April Billett. Asada Thomas, followed by April Billett.
Thank you. Good afternoon, Sentencing Commission. Thank you for the opportunity to speak here this evening. My name is Asata Thomas. I am the elected chair of the Philadelphia Reentry Coalition, as well as the director at the Institute of Community Justice, where we support persons who have been impacted by the criminal legal system, specifically mass incarceration. I'm speaking today to voice my opposition to the proposed new sentencing guidelines. They are antiquated, anti-restorative, and continues to only support the economic sustainability of mass incarceration by keeping persons incarcerated. Restorative justice, on the other hand, recognizes the harm done, identifies the needs and interests of those involved, and develops appropriate resolutions to hold the responsible party accountable, which include an intensive violence prevention program. Restorative justice not only lives up to these ideals, but it's also considerably more effective at creating safe communities in an efficient way. Restorative justice programs have been shown to reduce recidivism and have higher victim satisfaction rates than traditional criminal justice approaches. Moreover, restorative justice is an economically sound approach to criminal justice matters, especially considering the alternative. A recent Pew Research study estimated that increased incarceration accounted for less than 1/3 of the drop in crime in the United States since 1990. Yet states currently spend approximately $51 billion with a B per year on corrections, with a national recidivism rate of approximately 50%. Incarceration is a highly expensive yet highly ineffective means of handling crime. It is at intersections such as these, i.e., considering new sentencing guidelines, that the conversation about expanding restorative justice initiatives rather than increase and impose harder sentencing guidelines need to happen. In closing, I will add that the very few restorative sanctions that you currently propose for low-level behavior is not enough to move us forward towards real restorative justice, especially in 2022, when we should be moving in the direction of reducing mass incarceration and healing our communities. I am one of hundreds of RJ practitioners who would be glad to help find real solutions. As an RJ practitioner, I am clear that restorative justice is capable of undergirding criminal justice reform, and we need to look at expanding its premise rather than introduce sentencing guidelines that serve to further disenfranchise, disregard, and disempower Black and Brown persons. Thank you for your time.
Thank you for sharing your thoughts on the working draft of the guideline changes. Any comments or questions from any commission members? Any comments or questions from the online commission members? All right, thank you very much. All right, I am told that there is no one else who wishes to testify before the commission for this public hearing. So we will adjourn the public hearing and we will reconvene tomorrow morning for our regularly scheduled Sentencing Commission meeting at 9:00 a.m. All right. Thank you all very much. We stand adjourned.